symposium editor of the Civil Rights Law Journal. I'll keep this very brief. Thank you to all of you for coming, and thank you to our panelists. This is a very important issue, both in terms of statutory interpretation and the human impact that the interpretation at question here will have. And without further ado, I would like to invite up Peter Donahue, our editor-in-chief.
Hello all and welcome. Thank you for coming. I'd like to first introduce Commissioner Burrows. Commissioner Charlotte Burrows was nominated to serve as Commissioner of the EEOC by President Obama on September 12, 2014. She was confirmed to serve as Commissioner for a term expiring July 1st, 2019. Prior to her appointment on the EEOC, Ms. Burrows served as Associate Deputy General at the Department of Justice, where she worked on a broad range of legal and policy issues, including employment litigation, tribal justice, voting rights, and implementation of the Violence Against Women Act, among others. Commissioner Burrows previously served as General Counsel for the Civil and Constitutional Rights to Senator Edward M. Kennedy on the Senate Committee on Health, Education, Labor, and Pensions in 2009, and on the Senate Judiciary Committee from 2007 to 2008. After having served as legal counsel on the Senate Judiciary Committee from 2003 to 2007. Before working on Capitol Hill, Ms. Burrows served in the Civil Rights Division, Employment Litigation Section at DOJ, first as a trial attorney and later as a special litigation counsel, then as deputy chief. She served as judicial clerk for the Honorable Timothy K. Lewis of the U.S. Court of Appeals for the Third Circuit, and as an associate at, and I'm going to get it wrong, Dubois and Plimpton. Is that close? Ms. Burrows received an AB from Princeton University and a JD from Yale Law School. Again, we thank you so much for coming to speak to us, and I would now turn it over to Commissioner Burrows.
Good morning. Thank you, Peter, for that kind introduction, and thank all of you for coming. It's terrific to be here this morning, and I appreciate the chance to talk to all of you. And this podium is making it hard to see everybody. Uh-oh, did I just screw something up? To say thanks also to Jesse Holmes, who is going to fix my technological issues right now. But I have actually had the great good fortune to join EEOC this year and to have terrific staff, including Jesse, who has been in my office since May. And we're the primary office charged with interpreting the job discrimination laws, which, you know, most of you probably aren't in the workforce yet, and it's perhaps not at the forefront of your mind, but Americans, as you will see after you leave school, spend a ton of time at work. And it's an enormously important issue, not just for individual Americans, but for all of us and for the country, that they be treated fairly when they're there, so that everybody's talents and expertise is part of what makes the economy drive, so that we have really the opportunity to have everyone contributing. And that's one of the things that makes this country great. So it's terrific to be here with you. I thank all of you for this question, and you know, this is a question, the civil rights protections for lesbian, gay, bisexual, and transgender persons, that goes to the very heart of our most fundamental ideals: freedom and justice for all. That's the principle that makes American democracy work, and it's, you know, I really applaud the George Mason Civil Rights Law Journal's choice of this topic for its fall symposium, because it reflects your understanding that all of you, as the nation's next generation of lawyers, have a critical role in helping this country move closer to those ideals and to live up to those promises. From the very beginning, this country has aspired to justice as a means of protecting our most cherished values of freedom, liberty, equality, the pursuit of happiness. But that quest for justice had to contend with the very darkest of human sins, from slavery at the very beginning, prejudice, intolerance, and oppression. And in each generation, progress has depended in part on the vision of those who understand that our laws are not just a set of rules, but they're tools for justice. So let's talk about this critical issue of sex discrimination and the inclusion of sexual orientation and gender identity within the meaning of sex discrimination, which is very much on the front burner, not just for the EEOC, which again is the nation that is the part of the federal government that is lead on interpreting those job discrimination laws, but also, I think, on the front burner for the entire country right now. At the end of the last term, as all of you probably know, the Supreme Court issued one of the most significant civil rights decisions of our time, recognizing the right to marry a person of the same sex and have that marriage respected under law regardless of what state you live in. And although employment discrimination was not the subject of the Supreme Court's decision, as same-sex couples across the country have exercised their rights under the Obergefell decision, in some cases without support of their colleagues on the job, the Commission is increasingly faced with the question of whether this basic principle of equality for LGBT persons includes the right to work as well as the right to marry. And after looking at this and deliberating and looking at the development of the Supreme Court's jurisprudence in this area, the EEOC has decided that yes, we recognize the fundamental equality of all persons, and we recognize that under Title VII of the Civil Rights of 1964, employment discrimination on the basis of gender identity and sexual orientation constitutes unlawful sex discrimination. That interpretation is grounded in the statutory text and in established case law on the meaning of sex under Title VII. To make clear the Commission's views in this area, I'd like to first outline the development of gender-based protections and the definition of sex under Title VII. And second, explain the EEOC's recent decisions, exactly how we've wrestled with this, concluding that gender identity and sexual orientation are forms of sex discrimination under Title VII. So many early interpretations of Title VII, if any of you are taking employment discrimination law or constitutional law, talk about sex as do not recognize the full breadth of what that prohibition on sex under Title VII included. In the early days, before I went to law school, and certainly before any of you did, sexual harassment wasn't included under Title VII. It was not seen as what was meant by discrimination because of sex. And as the courts wrestled with these fact patterns in the early days, the sex discrimination laws were found to cover more situations than were initially thought. Courts made clear in those early days that employers could not refuse to hire someone just because she was a woman, but it took a lot longer for courts to address those employment practices that were based on cultural assumptions about differences between men and women. And in fact, in the 1970s, the EEOC itself took the view, and some courts agreed, that gender stereotyping was not prohibited, and that neither sexual orientation nor gender identity cases were actionable under Title VII. However, that changed at least by 1989 when the Supreme Court ruled on a case called Price Waterhouse versus Hopkins, brought by a woman named Ann Hopkins. And she was a senior manager at an accounting firm, Price Waterhouse, and she was denied partnership at the firm. In the year she was eligible for partner, she was the only woman of 88 candidates who were eligible. She had a record of strong performance, made a lot of money for the accounting firm, and many partners noted she was an outstanding professional. But others commented that she was too aggressive and abrasive for a woman. And she was told that her partnership was on hold until she could change the way she presented herself. I love this. Including walking and dressing more femininely, whatever that might mean. Styling her hair and wearing makeup and jewelry. And I have to add that those are all things that if she had been a man and she had done them, she would not have been considered for partner. The Supreme Court recognized that these comments, which led to the denial of her partnership, were motivated by sex, and that sex stereotyping, gendered assumptions about how an employee, in this instance a woman, is expected to behave is unlawful under Title VII. And building on this theory in 1998, in a case called On Call, the Supreme Court considered a case of male-on-male sexual harassment. Joseph On Call filed a complaint against his employer, Sundowner Offshore Services, alleging that he had been sexually harassed by coworkers while working for Sundowner on an oil platform as part of an 8-man team. On several occasions, On Call was forcibly objected to sex-related humiliating actions, and I won't go into them, but it was horrible and it was criminal, by his coworkers in the presence of the rest of his crew. He was sexually assaulted, threatened with rape. There's no evidence about the sexual orientation of any one of the actors, either the harassers or Mr. On Call in the case, and the court, I think, presumed that everyone was heterosexual. After complaints to his supervisor went unaddressed, On Call ultimately quit and filed a complaint under Title VII. The district court said, no cause of action. They're the same sex. They're your co-workers. Unfortunate, you probably should call the police, but no cause of action under Title VII. The Court of Appeals for the Fifth Circuit affirms, but in a unanimous opinion, and I think you guys have all been, I don't know what year everybody is, but you've been here long enough to know that unanimous opinions of the Supreme Court are not that common. By Justice Scalia, the Supreme Court reversed, holding that the workplace actions that On Call endured were discrimination based on sex, regardless of the gender of either the victim or the harasser, and regardless of whether the particular harm was foreseen by the drafters of the legislation of Title VII, the statute under which he filed suit. And in ruling that claims of same-sex harassment can be made under Title VII, the Supreme Court explicitly rejected the notion that the statute only forbids types of discrimination specifically contemplated by Congress. Rather, the court explained that statutory prohibitions often go beyond the principal evil they were passed to combat to cover reasonably comparable evils. And it is ultimately the provisions of our laws rather than the principal concerns of our legislatures by which we are governed. So applying these precedents, the EEOC has issued 3 important federal sector decisions interpreting the Title VII to protect LGBT employees. These are probably some of the most important cases on LGBT employment rights to date, although they're not things that are above the fold in the newspapers. These come out of our federal sector work with respect to federal employees who can file complaints with their employers, and those can be appealed to the commission. The first of these decisions, Macy versus the Department of Justice, concluded in 2012, and both I and Jeff Rosenblum, who you heard from a little bit, were at the Justice Department when that came down, so it was an interesting moment, that discrimination based on gender identity is a form of sex discrimination. And this case involved a police ballistics expert who was offered a job in San Francisco at the ATF. But that job was rescinded after she informed the employer during the background check process that she had begun the process of transitioning from male to female. So that sometimes happens. Just want to let you know, the fact that you're seeing these different names doesn't mean I'm using an alias for national, or that I'm a national security threat, but that I'm going through the transition process. And at the time of her initial interview for the position, she had been presenting as a male and using her birth name, which was a male name. In examining under Macy's complaint, and whether or not Title VII was at issue, the commission noted that the employer's discrimination against a transgender woman was sex stereotyping, as understood in Price Waterhouse, because Ms. Macy alleged discrimination that stemmed from the employer's perception that she was a man engaging in what would be considered feminine behavior. So the flip of Ann Hopkins, who was engaging in what they considered was insufficiently feminine behavior. Now she's engaging in feminine behavior. In explaining its reasoning, the commission relied in part on 11th Circuit precedents in a case called Glenn v. Bromby, explaining that the firing supervisor testified that his decision to dismiss the employee was based on his perception that it was a man dressed as a woman and made up as a woman, and admitted that the decision to fire her was based on the sheer fact of the transition. So the commission looked at that precedent, looked at circuits like the 11th Circuit, and determined that this was cognizable under Title VII, under the gender stereotyping theory, but also held that discrimination based on employees' change in gender status is inherently a matter covered by Title VII as sex discrimination. The Commission quoted powerful language from the U.S. District Court for the District of Columbia in a 2008 opinion. Imagine that an employee is fired because she converts from Christianity to Judaism. Imagine, too, that her employer testifies that he harbors no bias toward either Christians or Jews, but he has a problem with converts. That would be a very clear case of discrimination because of religion. No court would take seriously the notion that converts are not covered by the statute, and discrimination because of religion easily encompasses discrimination because of a change of religion. And it's exactly that reasoning that allows us to reach the transgender employees and to ensure that they have protection. More recently, in a case called Lasardi v. Department of the Army, the EEOC went on to define and help flesh out what constitutes a hostile work environment for people who are on the job. So Macy dealt with, we're just not going to hire you because you're transgender. Lasardi dealt with how they were treated once transgender employees are on the job. And in that situation, Tamara Lasari was denied access to a common female restroom following her transition from male to female, subjected to offensive slurs, and intentionally and repeatedly referred to by a supervisor using the wrong pronoun, i.e. he or sir, because it was sort of a military context, the Department of the Army, instead of she, with the intent of humiliating in front of coworkers. And I want to be clear that slipping up on a pronoun in and of itself is, the Commission has not taken the position that that's always a problem, but the intentional use of the wrong pronoun, as in sort of here it was a group of folks laughing, a supervisor was intentionally doing this over and over again to humiliate, and that's what the facts found. That was part of the hostile work environment, part of the sexual harassment in the workplace for that worker. So similar to gender identity, sexual orientation has been rejected by courts in the 70s as a basis for protection under sex discrimination in Title VII. But some courts later began to recognize that discriminating against employees based on their sexual orientation can constitute an unlawful form of gender stereotyping that violates Title VII. So as a result, instead of being dismissed out of hand for failure to state a claim under Title VII, several cases on behalf of gay and lesbian employees have been allowed to proceed to the merits in the federal courts. For example, in 2002, a case called Centola v. Potter, a district court in Massachusetts stated that an employee who was derided as effeminate, perceived as gay, and terminated after filing complaints about the mistreatment provided sufficient evidence to support the inference that he was harassed because of his failure to conform to coworkers' sexual stereotypes. And the court recognized that stereotypes about homosexuality are directly related to our stereotypes about the proper roles of men and women. The harasser may discriminate against an openly gay coworker or a coworker that he perceives to be gay, whether effeminate or not, because he thinks real men don't date men. That gender stereotype at work is that real men should date women and not other men, and that was actionable under Title VII. In 2002, in a case called Heller v. Columbia Edgewater, a federal district court in Oregon found that a lesbian plaintiff stated a Title VII claim by alleging discrimination based upon her failure to conform to her supervisor's stereotype, and I quote, of how a woman ought to behave. She's attracted to and dates other women, whereas her supervisor believes that a woman should be attracted to and date only men. Recently, a few courts have also discussed additional grounds upon which sexual orientation may constitute sex discrimination. One example, a case called Hall v. BNSF Railroad Company, issued just last year in the Western District of Washington, held that an employer's policy of providing health care benefits, this is a fact pattern that you're going to see over and over, it's going to be continue to be a very hot issue, health care benefits only to opposite-sex spouses, while denying those same benefits to same-sex spouses, may constitute sex discrimination under Title VII. The court accepted the plaintiff's factual assertions that, for example, if Michael Hall were married to a female, or if he himself were a female married to a male, then there'd be no problem, and he'd get his spousal health coverage benefits, as it does with all employees who are females married to male spouses, or males married to male spouses. So clearly framing the issue as one of differential treatment because of sex under Title VII. These cases have laid the groundwork for the EEOC's thinking on this, as well as, of course, Justice Scalia's opinion on call that we talked about earlier. So the third case I want to tell you about is Baldwin versus the Department of Transportation that issued just this past July. Following Macy and Lusardi, the court looked at the issue of sexual orientation discrimination, not transgender status, but sexual orientation as a potential basis for sex discrimination claims under Title VII, and concluded that sexual orientation is inseparable from and inseparably linked to sex discrimination, to sex rather, and therefore allegations of sexual orientation discrimination involved sex-based considerations. So I want to explain how we got there, because there is precedent. I'm sure there'll be a lively discussion, and as I mentioned earlier, going the other way as well. And we had the task of looking at the trends and trying to understand what would be the right interpretation of the statute to be faithful to its purposes and both the goals of and the broad remedial purpose of the statute. So first, sexual orientation discrimination. The commission said it's treatment that would not have occurred but for the employee's sex. That's fairly straightforward. For example, the discrimination occurred only because the employee was a man dating another man instead of a woman dating another man. And as in Hall, the discrimination in Baldwin was inextricably connected to the sex of the employee. Second, an employee alleging sexual orientation discrimination can raise a claim of associational discrimination, which is a claim that you're being treated differently because of who your friends are or who you're in a relationship with or who you associate with. And that theory has long been recognized in instances, for instance, where a white employee experiences discrimination because he's been or she has been associating with black coworkers or is in an interracial relationship. So just as discrimination against workers for associating with persons of a particular race constitutes racial discrimination, subjecting an employee to discrimination for associating with persons of a particular gender likewise constitutes gender discrimination. And courts and the commission have consistently held that associational discrimination on the basis of race is prohibited, and as Price Waterhouse notes, all protected classes under Title VII have to be treated the same. So that precedent is relevant here in the context of sex discrimination. The third reason that the commission set out was that employees alleging sexual orientation discrimination can claim that they're treated differently because the employer held gender stereotypical expectations about the sex of the person to whom an employee should be attracted. Thus, if an employee fires lesbian, gay, or bisexual employees for failing to conform to such stereotypes, it's clear under Price Waterhouse and its progeny that Title VII's been violated. So this Baldwin case on the one hand is groundbreaking, but at the same time the decision simply applies the well-settled principles of Title VII case law to Mr. Baldwin's claim and reiterates the fundamental requirement of Title VII that sex may not be taken into account in employment decisions. This is a logical interpretation of the plain language of Title VII and a natural evolution of sex stereotyping theory. Even if Congress did not envision this particular application of Title VII when the statute was enacted, consistent with the Supreme Court's decision on Cal, sexual orientation discrimination is within those scopes of evils that are reasonably comparable to the principal evil of sex discrimination, and therefore within the scope of the statute. So I should say as a sort of footnote that Mr. Baldwin has recently filed a separate complaint in the Federal District Court in the Southern District of Florida, so that will be interesting to watch, and we certainly will be watching it at the Commission. I'm pleased to say that in the same circuit, different state, it actually came out of Alabama, a district court recently looked at the Baldwin decision from the Commission and found its reasoning persuasive. The plaintiff did not win on other grounds, but the court made a point of noting that it in fact did think that this was fully that the sexual orientation discrimination concerns raised in that case were fully within the scope of Title VII. So I am confident that these issues will continue to come up in the courts, and that the direction of the courts is in this to reach the same conclusions that the Commission has done. We've, just to sort of put this in context, this is, as I said at the beginning, a cutting-edge issue. It's very important to people's everyday lives. We started back in January 2013 tracking information on charges that allege discrimination based on gender identity or sexual orientation. And even in just that short period of time, in fiscal year 2015, so the federal government has a weird thing where the fiscal year ends in September. So as of September last year, the year since that, EEOC received 1,416 charges raising LGBT discrimination in both the private and the public sectors, including 1,185 charges claiming discrimination on the basis of sexual orientation. So most of them are sexual orientation, not transgender, just by virtue, I guess, of the size of the populations. And that's up already from the previous fiscal year, 2014, when we received about 1,000 LGBT charges total, with about 918 being sexual orientation. So we resolved those cases already in our administrative process. We were able to get settlements and make a difference to people's lives. We were able to secure relief of some kind, whether through a negotiated settlement, mediation, conciliation, in 163 of those charges. It takes a while to investigate, so we have this process where we investigate and we are able to get relief once we figure out what's happened and we find that there's been a violation. In the last fiscal year alone, we recovered over $3 million in monetary benefits in settlements for conciliations of LGBT charges. And we're continuing to receive and successfully resolve complaints based on sexual orientation and gender identity. We've also filed several lawsuits and amicus briefs defending the rights of LGBT employees in the workplace, and have largely been successful in defeating motions to dismiss those cases outside of Title VII. Now, I don't know how many of you want to litigate, but I want to be clear, this issue is very much not settled in the courts. There is, as I said before, precedent still in the books, and I'm sure you'll hear more about that later, in some circuits that say categorically, nope, if you're talking about sexual orientation discrimination or transgender discrimination, you are out of court, at least as far as Title VII goes. And I think that one of the things that, in looking at that precedent and thinking about my own vote on the Baldwin decision in particular, is that you have to sort of think back to On Call and the sexual harassment that occurred there. If there had been evidence that the victim was gay, whether or not the result would have been different under those precedents. And that can't be the right answer, right? It can't be that if you go through egregious harassment that is sex and gender-based and focused on your behavior, then you can get relief if you're heterosexual but not if you're gay. That can't be the right answer. That can't be what the Supreme Court meant. And so thinking about that, you have to have a rule that doesn't carve out one set of the population under the sex discrimination statutes. I think it's also interesting with respect to, and I think the courts are getting to that, more and more courts are beginning to see that as well. This is continuing to be litigated. I found it very interesting that we recently had a amicus brief in the Seventh Circuit. So we sort of go in, even when it's not our case, and we kind of tell folks, hey, this is the way the law should be, as the lead government agency on employment discrimination. And that was a case in which there was a guy who had been working for Caterpillar. I guess they make, I don't know, whatever those big tractor things are. And he had sort of claimed sex and race-based discrimination on the job. And the issue that the commission came in to say was like, look, even though the sex claims sound in sexual orientation kinds of issues, it is still covered by Title VII. The Seventh Circuit had initially issued a panel decision that included a long litany of old precedent that predated mostly On Call, predated Price Waterhouse, and said, look, you just don't have a claim under Title VII. Out of court. Not on the sexual orientation stuff. And the commission came in to say, wait a minute, hold up. The Supreme Court has been saying a lot since some of the things that you've cited, and here's why it does fit squarely within the law. So this panel did something very interesting. It came back with a new decision, but it didn't cite any of that old case law. It didn't say over and over again, as it initially had, sexual orientation is not covered. That was all gone. It's as if somebody took a red line. They still didn't buy the plaintiff's argument on other grounds, but they took away everything that had said Title VII doesn't allow the sex discrimination cases to go forward because sexual orientation is not included. And I found that very significant. I think that we'll continue to see these. Again, if any of you want to be litigators, this is an area to watch. We are fighting it out, and others are fighting it out in every way you can imagine. I'm sure that the religious liberty issue will continue to come up, as it did actually post the Supreme Court's decision with the clerk who did not want to file petitions. I'm sure you all remember that. Interesting fact patterns. We've also had to fight, unfortunately, about the dignity and the privacy of some of the folks who've had the courage to come forward in our cases. We're currently in litigation with, of all things, a funeral home that fired a transgender employee. And they've been filing very invasive kinds of discovery requests, really icky stuff. We want to know all the medical records, we want psychological records, we want medical records on sexual anatomy, and demands for psychological records, and requests about parenting. And the courts have been, though, so far we've had a lot of success in pushing back on that. And the district court there said, and I couldn't agree more, such information is of the most intimate and private nature, and it would be harassing and oppressive to require its disclosure, at least at this juncture, where the requesting party has failed to show any relevance to the disposition of the gender discrimination claim, the sex discrimination claim. So while there's been a lot of progress towards protecting the rights of LGBT persons in the workplace, there's no question that challenges remain. To ensure that Title VII's protection against sex discrimination is fully enforced for all employees, the Commission is going to continue to address head-on the gender stereotypes and other barriers that have limited equal employment opportunity for LGBT persons, so that workplaces are welcoming of the talents and contributions of all employees, regardless of gender, sexual orientation, gender identity, or any of the other bases protected under the Civil Rights Act of '64. It's not only good for the nation's economy, as I said at the outset, but it's at the core of the broad remedial purpose of the 1964 Act, which the EEOC is charged with interpreting. So this issue, like many others, is going to be at the front burner of civil rights for many years. We're seeing rapid progress, I think. It's my hope and my expectation that by the time many of you are in the workforce, and certainly over the arc of your careers, that this issue will have changed the workplaces that a lot of folks are in, and that you'll find more welcoming and more inclusive workplaces than a lot of others who've come before you. And I should just say, this is particularly interesting and as a legal matter, and important just as a civil rights matter in those states where there is not protection under state and local statutes for LGBT persons. And so, as a Southerner, those are a lot of places where I grew up, and we're continuing to see that that is really on the cutting edge of how we're going to deal with some of these issues in the future. So I thank you. I look forward to a very interesting conversation. And without that, I will turn it back over to, I'm not sure, is Peter or? Okay, super. Thanks.
And I'm going to invite up Commissioner Burrows and our moderator now. Our moderator will be Jeff Rosenblum, who is currently Deputy General Counsel at the Security and Exchange Commission. He previously worked for the Department of Justice for 9 years and at the Department of Labor. He has taught as an adjunct professor at GMU Law since 2005, including several employment-related classes, which I believe includes employment discrimination.
Thank you. Thanks for inviting me and having me here, and thank you, Judge Burrows, for the very educational, fascinating talk. I guess now I'm going to be introducing the other panelists who will come up, and then we'll engage in some discussion. Ray Van, sorry, I'm not going to do that.
We're going to be having a discussion between you and Commissioner Burrows, and then question and answer, and then we're having a second panel.
Excellent. I was a last-minute fill-in, so I'm still getting used to the format, but that's fine. We'll roll with it. So we're going to have a discussion with me and Commissioner Burrows. Let me just, as a federal government employee, I have to give a disclaimer which says that all of my views here today are, any views that I might give are my personal views and not necessarily the views of my current employer, who is the Securities and Exchange Commission. So with that, I guess Commissioner Burrows and I, who happen to work together at the Department of Justice, dealing in all things of immigration law, although we're obviously here talking about employment law. So a couple things struck me. I think one thing, when I teach employment discrimination here, one of the things that I like to talk about, not sort of as much the legal side of it, but our laws reflect society, sort of our culture, right? And the way that our culture feels about things. And I think that when Title VII was passed in 1964, obviously it was a big deal at the time, and it had been a long time coming. And slowly, I think the public's view about discrimination and the, I guess, acceptability, or whether or not discrimination was acceptable, changed over time. And then you saw that really change with respect to other groups, and it's sort of one by one in terms of a focus. One of the things I wanted to mention, Commissioner Burrows mentioned a lot of times when talking about Title VII, the statutory text. And I think the reason she mentioned the text of the statute as opposed to some of the legislative history, does anybody know the legislative history of Title VII with respect to sex-based discrimination? Yeah? Another professor, yes.
You want me to say something?
Sure.
So it was introduced by opponents of the act as a killer amendment. They hoped that by having sex discrimination in there, that would motivate people to vote against the act, and therefore to defeat it completely. The expectation didn't work out the way that they planned, but that was the original idea.
That's right. So in 1964, when obviously race discrimination was such an important societal issue that they passed Title VII, the opponents of it figured that by throwing in sex-based discrimination, that no one was going to vote for that. So it would in fact defeat Title VII. Obviously the opposite happened, but because of that, there is very little, if any, statutory history on gender-based discrimination. So where a lot of times we'll go to the statutory history to interpret whether or not it's going to support further interpretations like the ones that Commissioner Burrows was talking about, we can't in this case. But slowly over time, that changed, and obviously gender-based discrimination, which was once at some points acceptable in some means, became completely unacceptable. I think you'll see that with disability law, both the Rehabilitation Act of 1973, the American Disabilities Act, which was passed in the early 90s. It seems to me, and I'd be interested in your thoughts and maybe even the audience's thoughts, that while obviously a lot of the cases you mentioned were very old, right, from the 80s that even dealt with this, that said Title VII doesn't cover sexual orientation discrimination. And so it's not that it's not a long time coming, this change, but once the change has started to happen, it seems to me that it has happened much more quickly, right? And it seems that society's views on this, I think the Windsor case, which you mentioned, which dealt with the same-sex marriage, that once that was decided, I feel like the shift in society has been somewhat palpable, and you mentioned how many complaints at the end have been filed. I was just wondering whether or not you had felt the same thing, or whether you felt this is still really a slow-moving acceptance of this.
So you have covered a lot of ground with that, and I should also say I'm delighted to be here with Jeff, who, it's true, we worked a lot together on immigration largely at the Department of Justice, and as I was sitting down, I was thinking, I wonder how, if I'm going to find out how annoying my pestering questions were in the midst of the immigration bill going through or not with this back and forth. So I'm delighted that so far so good. I've got questions I can answer. One, before I answer the last part of your questions, I do want to make one sort of addendum on the history of the coverage of sex under Title VII. While there were, of course, people who were hoping that this would be a poison pill, the principal sponsor of the addition of sex was someone who was sincerely pushing for this, and a lot of the women's groups were, less in the spotlight than some of the other civil rights movement, but there was also a sort of not very above the fold vocal push, but a real push both from the African American women movement and from other women to have sex included. And lest anybody think there's no point in looking at alleged history on sexual, on sex under Title VII, there were of course amendments. So, debatable. Certainly there was a poison pill thing going on and other things in 64, but when you get to the 72 amendments, and the Equal Rights Act was going on, and all of the, the sort of, some of the issues that, I don't know if any of you saw the New York Times interview with Ruth Bader Ginsburg and Gloria Steinem over the weekend, but it's worth taking a look at as they sort of reflect. But certainly by 72, there's some action in the legislative history on the issue of sex, but not on this issue. Not on this issue. So, I do think that there has been I don't know if you use the word sea change, but there's been some rapid evolution on this in a way. I think some of the first cases, Ulaine is the one that I'm thinking of, came out of the 80s, and frankly out of a time when not only culturally there were, sexual orientation, same-sex relationships, transgender status were not accepted, but they were actually criminalized. And so some of the backdrop of those early cases is the reality of Bowers v. Hardwick and some cases that said, you can make this criminal. So that is not explicit, I don't think, in any of the case law, but that is the reality of what, at the time in which that precedent developed. And I think it's important for the commission, and this gets back not out of a result-oriented kinds of thing or, a mission to be political about something, because there's another way to do that, and that's not what the commission has the authority to do. But in a duty to look at the statute with fresh eyes and not with eyes of a time when same-sex relationships were criminalized, but to sort of look at the issue fresh and say, what is it that you mean when you say because of sex? And you have to have a rule that covers everybody unless it says it's only specially for heterosexual persons. And so what does it mean if you're not going to carve out LGBT persons from the statute? What does it mean when you say because of sex? And so that's, I think, the EEOC, as I mentioned before, had its own precedent on those issues that went the other way, and we had to wrestle with that. But I think I don't know if you use this word sea change or if that's just sort of the word I'm thinking about it. There was a real difference as, again, before on call and after on call, there's a difference. And while there are certainly cases that, in the circuit courts even, that continued even after on call to say, no, it's not covered, you see the courts wrestling with it in a different way. And I think that the weight and the direction of the precedent is towards inclusion on this issue. I do think that's more just, but I also think that's really, truly more in keeping with a fair reading of the statute.
I think you had mentioned, I know you'd mentioned during your talk, and I just wanted to maybe flesh out a little bit, the sort of the EEOC's role in this and the difference between the public sector and the private sector cases. So the decisions, just to give some context for the folks that don't necessarily have the background, but the decisions that the EEOC issued, those are binding on federal government employees, right? And so specifically the gender identity ones and the sexual orientation, in the federal government, that is now prohibited. And it is not as clearly prohibited in the private sector where, and in sort of in the federal courts in the way that federal court jurisprudence has developed. And you mentioned a lot of the federal court cases and how I think they go different ways in terms of this issue. Sort of, what do you see as what's going to develop? I think you mentioned this a little bit at the end in terms of the federal courts addressing this issue, and what do you see as the EEOC's role? I think you mentioned this a little bit also in terms of filing amicus briefs.
Sure. So the way the commission operates, we have a policy arm, which is, we write regs and all that sort of thing, and we have a litigation arm. And if someone in the, on the job, regardless, if you're in the private sector, we talked a little bit about the public sector, but if something happens and you think it is a violation based on race, gender, national origin, transgender status or LGBT status, disability, age, etc., you can come to the EEOC and file a charge. And what that means is that then the EEOC has an obligation to investigate, and if we can't get to it quickly enough, we will, and you need to vindicate your rights in court, we'll issue a notice of right to sue, we also are empowered to file suit on behalf of individuals. So particularly for folks who just, they're busy, they're going around their lives, but they have been wronged, but they can't necessarily afford to go get their own lawyer. That's one of the most important things that we do, is to take their issues before the courts. So we have filed 3 or 4 issues on behalf of transgender employees. I mentioned one earlier where we were sort of duking it out in this kind of nasty discovery fight about what medical records are going to come out and why that's not even relevant. But we also have the ability to, file on any one of these. I think I mentioned there were 163 where we were able to get settlements. If any of those had not settled, we would be in court. So that's something that we will continue to do. I am a little concerned that the numbers we've seen are just the tip of the iceberg, because there are a lot of places where folks don't realize that we do this, don't understand that they have rights, or don't come forward because they fear retaliation or whatever else. But we will continue to do that work. The other thing is that we will continue to file amicus briefs strategically in those cases where we think we can have the most impact. The Seventh Circuit amicus brief, where we sort of weighed in and said, wait a minute, Seventh Circuit, not correct to say that, looking at all those old precedents, Title VII doesn't reach sexual orientation discrimination, and they took it out. And as we look at the circuits where this issue is still open or where we think they have reached the wrong decision, we will continue to do that. So, and I think that the Seventh Circuit's, at least that particular panel's decision to not make those statements is an important signal that might be someplace where we should continue to be raising the issue. So I think those things will continue to happen. There was a case that got a ton of attention in the press recently. I don't know if you saw it, but Saks Fifth Avenue, I guess, was sued with respect to a transgender employee, and there was a brief that was filed, and very, very uncommon. I don't expect to ever see this again, but the Saks basically folded and settled and dismissed the whole thing. I always think it's because right after our brief was filed, but I think the media probably had a lot to do with it. And when I talked to my friends at Justice, they're like, no, it was our brief. And it was like, no, it was our brief. But, so we will continue to, where we think it's important to have the federal government's interpretation out there, we'll continue to file those briefs.
And do you think this is likely to wind up before the Supreme Court?
It may. It seems that there's a lot of litigation out there, unfortunately, and that is how big issues tend to get sorted out. I have no crystal ball on that one, but it seems as likely as anything.
So what would you say to the argument? And I think that a lot of the protected classes that have been, where discrimination is prohibited is done directly by statute. And this is obviously an interpretation of Title VII, which existed, which, whether or not it's the interpretation, a correct interpretation or not, and I think there are a lot of people think it is, but there's at least an argument that it wasn't what was initially obviously intended by Title VII. So how would you respond to the argument that this is something that should be addressed by congressional act as opposed to by interpretation of Title VII to broaden its scope?
Well, I think the very fact that the question is out there suggests that maybe it should be, and I don't know if any of you all are familiar with the Equality Act, which includes a lot of things. It was recently introduced in, I think in both houses of Congress, but would include things like public accommodations, folks who refuse to, a hotel who refuses to serve LGBT persons because of sexual orientation or gender identity. It includes protections in education, and it includes an amendment to Title VII to say explicitly sexual orientation and gender identity. So I don't have I think that that's a great idea, because it sort of, saves the courts and the litigators a lot of time and energy, but I don't think that the fact that that has not happened absolves us of our duty to figure out what the statute means, given the precedent, given the fact patterns that we're seeing, and given the sort of plain meaning of the reading. So I personally would welcome that. It would sort of, save everybody a lot of time, but I don't think, that we can say, hey, Congress didn't say it explicitly, that we have statute, again, it doesn't say sexual harassment either, and it probably, would have been faster for sexual harassment to be written into the statute as that went on, and rather than have a decade or 15 years or 20 years, whatever it was, of establishing sexual harassment as a kind of, and as a form of sexual discrimination under Title VII, but didn't mean that if Congress doesn't act, you can sort of ignore the fact scenarios that come before us. And we have a duty to look at the charges that come to us and take seriously the claims on their merits with the statute that we have.
Yeah, I would say I think I think the sexual harassment analogy is an interesting one, because I talk about it a lot in class. Like, sort of if you think of sort of the basic framework of employment discrimination, it's you can't, you shouldn't, or you can't, you're prohibited from treating this person differently because of their fill in the blank. That's sort of the disparate treatment, right? You can't treat somebody differently because of whatever it is, their protected class, their age, their race, their gender, their disability. And the sexual harassment is interesting because that really did broaden the scope of it. The way that the language of Title VII is written is it says that you're prohibited from discriminating because of sex. And it seemed to me, and again, without having looked back at it, it seemed to me what they meant by that was because of gender, right? Because of the person's gender. And arguably, under that theory, if what they really meant was you can't discriminate against someone because of their gender, sexual harassment arguably wouldn't be covered because theoretically, and I would like to give this example or this hypo in class, what if you have a supervisor, let's say, who is harassing both men and women equally, right? And so he's an equal opportunity harasser. And so the argument I think you would be under a traditional disparate treatment theory is, I am not doing this because of this person's gender. I don't care what gender this person is, I'm going to harass them regardless of their gender. And so I think that the sexual harassment actually is somewhat an expansive reading of Title VII, at least the way it's written. It says because of sex. And I think that this new interpretation is very much in line with sort of the development of sexual harassment. I know
I agree
there's
with
not a question there. There's not a question there. There's just my comments. The other questions I had. Let's see. So sexual orientation discrimination, let's focus on that for a second. That was prohibited in the government previously by executive order. So it didn't quite have all the same protections because you didn't actually get to go up to the EEOC to get a decision. But I think it was a Clinton executive order that prohibited discrimination based on sexual orientation in the federal government. And so I think you answered this a little bit at the end of your talk, but how has that, so in some ways, this broader interpretation hasn't really changed the law for federal employees. What have you seen as sort of the practical effect of these decisions?
I'm glad you asked that, and I'm going to try and answer it without getting all weedsy and lawyerly about it. If you are harassed, a lot of times what you need are damages for emotional distress. You're stressed out, but no one fired you, so you didn't lose back pay. No one refused to promote you. You've just been going into work, cringing all day, door shut, not being able to take the day-to-day. So what are the damages for that? Under Title VII, you can get money for emotional distress. You got to prove it up, but you don't have to prove that you went crazy or anything outlandish like that, but you can get money for that. Under the EEO laws and under the executive order that the president has issued that only goes to, sexual orientation as a non-merit-based practice in the federal government is what they call it, you can't get any emotional distress damages. So that's a real-life, basic kind of thing. And it's not because the executive order or the White House didn't want to cover it, but there's this whole rule about that you have to have Congress say it's okay if you're going to give money to people. This is the short answer. So the bottom line on that is it makes a real difference if what you're experiencing is harassment on the job on a daily basis. If you get fired or lack of promotion, those kinds of things, there was more of an ability to reach it. But that there's some, particularly if you're talking about somebody who's transitioning in the workplace and goes through harassment from coworkers, which is a scenario we see far too often, it's the emotional distress damages that matter. So that's one way. I think it also has raised the visibility and helped people understand that they do have rights, that the federal government is committed to protecting them. And so the additional attention that came from the decision being out there has actually helped people understand that they don't have to take certain things at work. So I think of the federal government as a good employer. I hope that not overly optimistic, but when things happen, people need to know that they have a way to redress them. So I think it's been helpful.
And you'd mentioned some statistics. Has the numbers gone way up in terms of complaints filed based on sexual orientation?
The way up is hard because we didn't really track this before Macy. So I don't actually know the answer. So we started tracking really, Macy came down in 2012, and our first full fiscal year is 2013, which is the same, again, because of those weird way we do years in the federal government, it's the same year as 2012. And so, yes, there have been increases, but to really sort of look over the arc of people's filing complaints, it's hard to say because we're really only looking at a couple years worth of data.
So I think we have time for a question or two from the audience, and then we'll go on.
Okay.
Cool.
Great. Audience members. Question or two? Yeah.
Commissioner, you had mentioned the impact on religious organizations. I was wondering if you could go into that a little bit more. It seems like a decision like Hobby Lobby could be on a collision course with the interpretations of Title VII that you've talked about today. I was just wondering if you could go into that a little bit more in terms of, in particular, benefits given to perhaps by a religious organization or not, and not given to others based on sexual discrimination or gender discrimination.
Well, I'm glad you asked such a simple and straightforward question. I wasn't referring so much to religious organizations, but the religious sort of discrimination claims or concerns that have been raised. And from my perspective, as somebody who grew up in a very religious family, my grandfather was a Baptist minister, I take very seriously those concerns. I think that it's important. I don't know that I would say it's the collision course, but I do expect they will continue to come up. Hobby Lobby, interestingly enough, deliberately did not take on the Title VII issue. It explicitly says, we're not talking about Title VII here. So, that was a punt, and I guess that meant that, now we catch the football from the Supreme Court on that. But I think that, in the employment context, there is obviously the responsibility to have religious accommodation. So there's a religious accommodation line of case law for someone who wants to raise a claim to say, I don't want to do X or Y, or I need to do X or Y because of my religion. And an employer is supposed to accommodate that unless it would cause more than undue hardship, and that's sort of been interpreted as something under a case called Transworld Airlines, something more than de minimis. So you can't say you can't have your Sabbath off just because you don't want to rearrange the schedule, kind of thing. Here, it's interesting because you raise the religious employer. There are certain, obviously, if you're talking about a church, there are certain exemptions, and there are different ways of analyzing it. And I think that case law, except for exactly in the Hobby Lobby area of who can claim that religious exemption as an entity, as an employer, I think that's going to continue to develop. I think that the other issues, both religious accommodations in employment for the workers, and also for, sort of on the other extreme with clearly, again, it's the, fill in whichever church, or the person is in a ministerial position with, say, a religious school. That law is pretty well, I won't say firmly established, you can always think of things, but there's pretty clear guidelines on those. But I think you're right that the Hobby Lobby will continue to develop, and that we'll see those fact patterns, both here and in all sorts of other contexts. And I am not going to predict how that will develop, but I think that particularly on those issues, facts matter a lot. It's really fact-specific. But those are important issues. They will continue to come up, and I think that there are really good and important interests on both sides.
I wanted to thank Commissioner Burrows for being here today and for speaking with us.
He's kicking me out.
Yeah, well, we have, it's time for our second panel. Unfortunately, we are having a case of missing panelist. But I'm going to invite up Professor Ilya Somin of George Mason Law School and Ray Van, General Counsel at the EEAC. And hopefully we will be having another panelist joining us.
Am I supposed to take this seat? Yes. Oh, actually, or, thank you. Logistical difficulty.
All right, I will go ahead and give the intros. Ray Van is the General Counsel of the Equal Employment Advisory Council. She is Vice President and General Counsel, actually. Among other things, she oversees the preparation and filing of friend of the court briefs with the U.S. Supreme Court and federal courts of appeals in significant employment law cases. She has more than 20 years of experience in assisting employers with their workplace compliance needs. She specializes in providing advice and counsel on mitigating individual and systemic discrimination risks, establishing effective alternative dispute resolution procedures, and conducting thorough and effective investigations into allegations of workplace misconduct. She is one of 16 national experts selected to serve on the EEOC's Select Task Force on the study of harassment in the workplace. She received her BS in Public Policy and Management from Carnegie Mellon and her law degree from the University of Connecticut School of Law. Professor Ilya Somin, here at George Mason. His research focuses on constitutional law, property law, the study of popular political participation and its implications for constitutional democracy. He is the author of The Grasping Hand, Kelo versus City of New London, and the Limits of Eminent Domain and Democracy and Political Ignorance, Why Smaller Government is Smarter, and co-author of A Conspiracy Against Obamacare, The Volokh Conspiracy and the Healthcare Case. Somin's work has appeared in numerous scholarly journals, including the Yale Law Journal, Stanford Law Review, Northwestern University Law Review, Georgetown Law Journal, Critical Review, and others. He has also published articles in a variety of popular press outlets. From 2006 to 2013, he served as co-editor of the Supreme Court Economic Review, one of the country's top-rated law and economics journals. And he also co-authored an amicus brief to the Supreme Court in the recent same-sex marriage case, thank you, versus Hodges, arguing that same-sex marriage bans constitute sex discrimination. I figured you were right here, so I might as well, rather than mispronounce it myself. So please welcome Professor Somin. So are we doing the same format, just a
5-minute or so of openings if they want, and then questions and answers to you, and as you see fit.
great. So do you want to give a little opening?
Sure. Thank you very much. I appreciate the invitation to come speak to you on this topic. I'd like to unpack the issue from a different perspective. I am a management attorney, so I have a different view of how, sort of stemming from the text of Title VII, the EEOC's LGBT anti-discrimination policy position has evolved. We've talked about Title VII throughout the morning. Title VII was enacted in 1964, bars discrimination on the basis of race, color, religion, sex, or national origin. I want to say a word about this 11th hour amendment to Title VII to add sex. I tend to fall in the camp of those who believe that it was an 11th hour effort to torpedo the bill, although there has been a very lively debate over the Howard, I can't remember his last name, the legislator who introduced the amendment was, by all accounts, one of the most vicious and nasty segregationists. He was a racist, by all accounts. Some believe that he was very close to the cause of gender equality. So that's where the debate comes into play. I still think that he introduced it because he knew that the all-male Congress would never pass an anti-discrimination law if it required businesses not to discriminate on the basis of gender. But anyway, trivial information. I digress. I just needed to get that out off my chest. But back to this LGBT issue. So I think that I would like to frame the issue by offering up a question. And the question that I would offer to you is whether or not the courts, Congress, and the EEOC, as well as some other federal agencies, are all on the same page with respect to what the law currently prohibits in terms of workplace discrimination. You heard Commissioner Burrows talk about the evolution of the EEOC's position on this. And you heard her talk about very important legal doctrines, case law developments, including the Price-Waterhouse sex or gender stereotyping doctrine, as well as how sexual harassment and same-sex harassment has developed in the courts. No federal appeals court in this nation, including the U.S. Supreme Court, has accepted the EEOC's view, as recently expressed in the Baldwin case, that Title VII prohibits LGBT discrimination outright. For many, many years, plaintiffs, federal court plaintiffs, as well as the EEOC, have been very successful in protecting the rights of individuals who claim that they have been discriminated against based on, under a gender stereotyping theory. So individuals who are fired or not hired because they fail to conform to what the employer's expectations are as to how a man or a woman should act. Those claims have been fairly successful for a number of years in courts under this gender stereotyping theory that was established by the Supreme Court in the Price-Waterhouse case. No, and hear me, the U.S. Supreme Court nor no other federal court of appeals has agreed with the EEOC that Title VII prohibits sexual orientation or gender identity discrimination outright. Why? Because the statute doesn't say anything about that. It prohibits discrimination on the basis of race, color, religion, sex, and national origin. Now, the reason why I'm so all in or committed to this textual position is because of what Congress has and hasn't done over the years. So since at least 1994, Congress has debated enacting a standalone federal law that would prohibit discrimination on the basis of sexual orientation and gender identity. That's the Employment Non-Discrimination Act, or ENDA. ENDA has been introduced and reintroduced in Congress for decades, and it has failed to gain traction and momentum in the Congress. So Congress has failed to pass a law, federal law, to prohibit discrimination on the basis of sexual orientation and gender identity. Plenty of states have. A number of states prohibit workplace discrimination on the basis of LGBT status. Congress has deliberated it, considered whether or not a federal law is needed to prohibit this type of discrimination in the under federal law, and it's basically punted. You heard Commissioner Burrows mention the Equality Act, which was introduced in July of this past year, or July 2015, this past summer. The Equality Act, as opposed to ENDA, would actually amend Title VII. So ENDA has been proposed as a standalone law. The Equality Act would amend Title VII to incorporate legal protections on the basis of sexual orientation and gender identity. So I don't know how much clearer the textual argument can be that Title VII currently does not prohibit discrimination on the basis of sexual orientation and or gender identity. It's really just a strict textual position. Now, let me stand back and say that I'm not aware of any major corporation in the United States, certainly not those on the Fortune 500 list, that does not have a company policy that strictly prohibits discrimination on the basis of sexual orientation and gender identity. And in fact, President Obama last summer, and this is July 2014, passed an executive order, hold on, 13672, which prohibits federal government contractors, so companies that do business with the federal government, from discriminating on the basis of sexual orientation or gender identity. So there's a large swath of the largest companies in the U.S. who not only make it their corporate policy not to discriminate on the basis of LGBT status, but are also now affirmatively required by law to ensure that their workplaces are free from discrimination on the basis of sexual orientation or gender identity. So again, I think that it is important to state from a philosophical standpoint that American business stands behind efforts to outlaw discrimination on the basis of LGBT status. But as a legal matter, we have to have the text and we have to have the support behind it. I want to say a word about the EEOC and its enforcement role as well. Commissioner Burrows, and I think Jeffrey talked about it as well, fleshed it out a bit. The EEOC's role in the federal sector is different from its role in the private sector. So the agency cannot adjudicate discrimination claims brought against private sector employers. Its obligation is to investigate claims that employees or applicants for employees bring to it, okay, under the laws that the agency enforces. If the EEOC investigates and finds reasonable cause to believe factually that discrimination has occurred, it can do one of a couple of things. It can either, well, it is obligated to try to resolve that matter through negotiation, through settlement. It's called conciliation, okay? If conciliation fails, then the agency can either issue the charging party a notice of right to sue, which is their pass to go into court and basically start the whole thing all over again, or it can itself file a lawsuit in federal court and basically step into the shoes of the charging party and pursue that case as the plaintiff. But the agency's actually prosecuting its own case. It's got to prove its own case as a private plaintiff would have to do. Okay, so that is a very important distinction between federal sector and private sector EEOC processes. And that's why the Macy and the Lusardi and the Baldwin decisions that Commissioner Burrows talked about, really have no force and effect of law in the private sector at all. And that's why Commissioner Burrows made the point of mentioning that there is a district court that has reflected upon the policy positions that the agency took in those decisions in kind of examining the issue on its own. The fact that one federal district court would look to the agency that has enforced Title VII for over 40 years is not surprising, right? Federal courts are not going to accept the Macy decision or the Baldwin decision or the Lusardi decision as controlling law, though, because they're not in any way, shape, or form controlling on the federal courts. The other thing that I would point out that is fairly significant, again, from a textual standpoint, and I don't mean to cast any aspersions on the EEOC or Commissioner Baldwin, Burrows, or anyone in any way, shape, or form. As I said, we are philosophically aligned with society's movement towards greater protections in every context against LGBT discrimination. But the EEOC actually was created by Congress in Title VII. So there's a part of the statute that says there shall be an EEOC, and this is what the EEOC should do. When Congress created EEOC, it gave the agency the authority to promulgate, to issue procedural regulations, suitable procedural regulations in interpreting Title VII. So, in fact, the EEOC does not have substantive rulemaking authority under Title VII, which means that it cannot say, well, we interpret Title VII sex discrimination provisions to reach sexual orientation. As a matter of fact, end of law, it cannot say that with any authority. It does not have the authority under its congressional grant to make those types of, to take those types of legal positions. So what it has done is develop its policy around this issue. And the EEOC's policy developments, again, have outpaced what Congress has been doing and what the courts have agreed constitutes a reasonable interpretation of Title VII. Back in 2012, the EEOC adopted a 5-year strategic plan and an accompanying strategic enforcement plan, which identifies a series of national enforcement priorities. One of the national enforcement priorities that the EEOC outlines is discrimination on the basis of LGBT status under Title VII. And it lists that issue in its strategic enforcement plan as a new and emerging issue. So again, that's 2012. The agency can't have believed when it adopted that national enforcement priority that Title VII always protected LGBT individuals against discrimination as a form of sex discrimination. It's just intellectually dishonest to even purport to say that, and they have not, the agency hasn't said that. But I think in the spirit of full disclosure, you ought to know that even the EEOC, as recently as 2012, said that this is a new and emerging legal issue. So, and Commissioner Burrows did indicate in her remarks that the issue is far from settled. It really is quite unsettled in the courts. The EEOC is developing policy, which I think legitimately it's doing in order to push Congress and lawmakers to do something, to act. But the agency on its own cannot just decide that, well, after 40 years, we now believe that because of sex under Title VII extends to LGBT status. Now, the agency's federal sector decisions, as I said, don't have any real impact on what happens in the private sector. But as Commissioner Burrows mentioned, the agency has filed a series of public enforcement actions against private sector employers that aim to achieve the same result. It's going to be far more difficult, though, because again, to the extent that the courts are looking at settled precedent, the settled precedent establishes claims based on gender stereotyping, not based on discrimination outright because of sex. I'll reserve the balance of my time for questions or comments.
Excellent. All right. Professor Somin?
I'd like to start by thanking the Civil Rights Law Journal for organizing this event and all of you for coming. And in this presentation, I'll be taking, at least in some points, an unaccustomed for me position of moderation. In that, on the one hand, I do agree with what the Commissioner said earlier today, insofar as she argued that sexual orientation.
No one has this number. The only time it ever calls is like when it's a timeshare. I apologize. So.
So at least it was his phone that rang and not mine. As I was saying, I'm in an unaccustomed position of moderation here, in that on one hand, I do agree with what the Commissioner said earlier when she argued that sexual orientation discrimination is discrimination on the basis of gender. On the other hand, I do not agree that the court should currently interpret that as violating Title VII. And going forward, as I'll briefly discuss at the end, I think there are important differences between public and private sexual discrimination that need to be taken account of when we consider what kind of policy we actually want in this area. So first things first, I do think this is sex discrimination. Indeed, as was mentioned earlier, I had actually co-authored an amicus brief in the Obergefell case where we argued that it is sex discrimination to forbid same-sex marriage. I co-authored that with Professor Andrew Koppelman of Northwestern University, someone with whom I very rarely agree on anything else, but we agreed on this point because when you say that it is legally permissible for you to marry a woman if you're a man, but if you're another woman, you can't do it. That's a classic example of your legal rights being determined by your gender, and that is sex discrimination, just as it's race discrimination if your legal rights are determined by your race. And I think the same thing may be true in the area of employment discrimination. If you fire a man who dates if you fire a man who dates other men, but you wouldn't fire a woman for dating men, then you're essentially saying that someone is being treated differently solely on the basis of their gender. But there is an important but here, which is it doesn't necessarily follow the courts can now say, well, Title VII covers this form of discrimination. If we were just looking at the text of Title VII in 1964, I might very well say, well, yes, this does cover this kind of discrimination because logically speaking, it is sex discrimination, and the text seems to cover all types of sex discrimination. But we're not looking at a blank slate here. We have several decades of precedent from courts, from executive agencies, from congressional acquiescence, and other kinds as well. And the Supreme Court has repeatedly said that when it comes to statutory interpretation, it will not upset long-standing precedent unless there's an overwhelming case for doing so. And until very recently, there is virtually no federal court precedent at all that ever concluded that Title VII covers sexual orientation discrimination. Virtually all the cases had gone the other way. Even today, while Commissioner Burrows gave you a very thorough account of the relevant precedent, she was only able to cite a couple of very recent cases which ruled that Title VII covers this form of discrimination, and are all from district courts, I believe, which means that they're not even binding precedent. Technically speaking, district court precedents are not binding. So I think given this long-standing accumulation of precedent, I think it's too late to effectively argue that Title VII covers this form of discrimination, even though as a textual matter, if we were back in 1964, perhaps things, at least a matter of logic, would look different. There are many reasons why the Supreme Court believes that there is a different approach to statutory precedent versus constitutional precedent. I don't have time to get into all of them, but one of them is the reliance interest, but the other big one is that with statutes, they can be changed by other statutes, by legislation, whereas incorrect interpretation of Constitution can only ultimately be changed by the court or by constitutional amendment. So there's a stronger case for overruling bad precedent in that area. There are some people who say we shouldn't have this approach to statutory precedent. We shouldn't defer to bad precedent. We should just overrule it. If that's your view, I'm happy to discuss it. But notice that that view has radical implications for a lot of other areas. It's a tail that would quickly start wagging the Title VII dog. So if you want to make that argument, you have to confront all of its other implications. Finally, I think there is this issue of the public versus the private sector. As you can guess from the fact that I wrote the sex discrimination brief in Obergefell, I actually do think that sex discrimination by the public sector, not just sex discrimination, but also sexual orientation discrimination is unconstitutional because it is a form of sex discrimination. And I think part of the reason, obviously, is that the 14th Amendment applies to the public sector but doesn't apply to the private, so some of it is just a purely legal argument, but some of it is a broader moral and policy argument as well, that I wouldn't actually want, I believe, a law that applies this form of anti-discrimination provision to the private sector. And I'll just briefly summarize a few of the reasons why. One is that there's a big difference between the public and the private sector. Most public services are actually monopolies. If you can't, at least under current law, if you can't get a marriage license from the government, you can't get a legally binding license from anybody else. If you can't get certain kinds of government services or protections, most of the time there's no one else you can go to get them, and so on and so forth. By contrast, with the private sector, if you can't work for one employer, that's not necessarily a huge problem. There are many other employers available in most industries. Maybe it's different if all or most employers overwhelmingly share the same prejudices, even then there can be competitive pressures to hire good workers. There's a history to suggest that before southern states enacted Jim Crow laws, there was actually competitive pressure to hire black workers, even in that era of overwhelming racial prejudice. Today, of course, while there clearly is still homophobia out there, and I in no way mean to deny that, nonetheless, the overwhelming majority of employers and the overwhelming majority of Americans generally believe that it's inappropriate and undesirable to discriminate in hiring on the basis of sexual orientation. So what we're talking about is a small minority of employers. And I think that significantly differentiates the public and the private sector. Finally, I think there's an important principle of freedom of association, whereas a government employer belongs to the people as a whole, to the entire nation, and therefore I would argue has an obligation to hire the best workers, to ignore morally irrelevant characteristics, including sexual orientation and race and gender and others. I think a private employer is in a different situation. A private employer is themselves the owner of their own business, their own property and the like, and they're not, I think, morally or legally obligated to serve the entire public in the same way that a public employer is. There are unusual exceptions, perhaps, private employers who are monopolists, such as public utilities. I think maybe different rules should apply to them, but for the ordinary private employer, I think the rule should be freedom of association. And just like freedom of speech must include freedom of speech for the thought we hate, freedom of association must include freedom of association on the basis of principles that we correctly oppose and despise, including various forms of prejudice or hostility to different groups that as a moral matter we would quite rightly condemn. Now, obviously, some of these principles would say, well, what about traditional racial discrimination under Title VII? Maybe as a matter of principle, these ideas apply to that as well. I think at some level they do, but I also think the historical situation with Title VII in 1960s applied to race was very different. I can't go through all the different reasons why, but I will merely mention as of that time, particularly in the South, but even in some places elsewhere, there was an enormous history of government pressure and coercion preventing employers in many cases from hiring blacks and other minority groups. And it may be that at that time, the only way to overcome that was through an employment discrimination law that covered the private sector as well as the public. So in that unusual and truly terrible historical circumstance, there may not have been any way to have, for the government just stand back, either allow the existing system of coercion to continue or it put forward some coercion of its own. I think the situation today with gays and lesbians is quite different, and I'm happy to expand on that in questions. So on that, I think we can open things up to the audience.
If our moderator has any questions.
Sure. I guess I'd just like to frame it. I'm sorry that Commissioner Burrows left, because I think she would probably have some interesting responses to some of this. I guess let me just I want to frame your comments before we get some audience questions. So it seems that you both are in disagreement with the EEOC's interpretation of Title VII to include these additional rights. Is that a fair characterization?
I think so. Let me be clear that I don't believe that Title VII prohibits LGBT, I don't believe that Title VII creates an LGBT protected class. And I don't think that you can backdoor that protection through sex. But I do believe that there are theories of discrimination that can apply to individuals based on their LGBT status.
Such as Pricewaterhouse?
Right, such as gender stereotyping.
So I'm in agreement with their interpretation of the text. If all we had was just the text of Title VII, I would say it covers this form of discrimination, but I'm in disagreement with the idea that courts or the EEOC or anybody for that matter can overturn many decades of precedent in this area without a new statute passed by Congress. That rests on a theory that statutory precedent deserves greater deference than constitutional precedent, which is contestable, but which is and has been accepted by the Supreme Court for a long time.
And I guess my follow-up to that, and I think you answered this, which is that you wouldn't be opposed to necessarily a statute that would pass these rights. You're just saying
not.
the courts haven't done it.
That's right.
Yeah.
what Professor Somin, but
Yeah.
you did spend a lot of time talking about sort of the
Yeah.
differentiation between the public sector and the private sector, and how in the public sector these rights might be appropriate, but not necessarily in the private sector.
Yeah, I would be happy to see a statute as kind that applies to public sector and also to certain specified private employers and entities that are essentially monopolists in their area. But I would not want to see a law like this for the private sector generally.
Okay, and I don't want to go too far down this rabbit hole, but I have to ask before we take audience questions is, so you had mentioned race discrimination. So in
Yeah.
differentiating between the public and private sector, you mentioned race discrimination, but I guess I would bring up the fact that most protected classes are protected in both the federal and the private sector. So you're talking about to all of the ones under Title VII, which are, race, color, religion, national origin, and sex, and then you're talking about the Age Discrimination and Employment Act, you're talking about Americans with Disabilities Act. So the overwhelming majority of the, I guess, easily identifiable protected classes are protected the same way in both the public and the private sector.
Yeah, they are, and I dissent from the orthodox and I'd call it overwhelmingly dominant view on this. I think there are relevant distinctions to be made between the public and the private sector, not just with LGBT discrimination, but also with age discrimination, disability discrimination, and most of the other cases that you mentioned. As I said earlier, given the particular history of race discrimination and ethnic discrimination, particularly as it had developed by the 1960s, I think there was a strong case at that time for adopting race discrimination laws that apply to the private sector as well. But I think that is based on a particular history of government and also private coercion that exist on a massive scale in that instance that was not comparable in most of these other cases that you mentioned.
So just to be clear then, it's not that this particular protected class of LGBT, I get the initials wrong, I always do, that shouldn't necessarily be, but you think that in addition that they should be treated similarly to age, disability, et cetera, and that none of them should be covered in the private sector?
Yeah, I believe that, as I said before, that there should be a principle of freedom of association that applies to private sector but doesn't apply in the same way to the public, and that principle is not limited to LGBT cases. It applies to all these other situations as well.
I think now we know where everybody is, so it would be a good time to open up for audience questions.
Hi. My question, I'm also a strong believer in textualist interpretation of statutes. So I was wondering what your opinions are about a strict textualist interpretation given the Supreme Court's recent decision about the Fair Housing Act and extending it to desperate treatment, saying that
Disparate impact, I think you mean.
Disparate impact.
yeah, okay, so I just wanted to make sure I got this quotation right. The majority wrote, recognition of disparate impact claims is consistent with the Fair Housing Act's central purpose of ending discriminatory practices. So using an analogous form of reasoning, couldn't the same case argument be made that, oh, well, LGBT discrimination is within the same central purpose of the Title VII of the Civil Rights Act?
Well, can I begin? Should I
Yeah, go
begin?
ahead.
Please.
I think that's a really good point, but I think there's a big difference between a protected status versus recognizing a potentially expansive theory of discrimination. And the Supreme Court, in the Griggs case, did the same thing decades ago with respect to Title VII. Title VII, when it was enacted, did not speak to disparate impact. So disparate impact discrimination is unintentional discrimination. It's the use of a policy, practice, procedure that has a statistically significant adverse impact on an entire protected group. That's not discrimination because of sex. It's not disparate treatment, but it has the effect of discriminating essentially against an entire group of individuals. And that use of that type of practice has to be justified. So I think that the courts up to and including the U.S. Supreme Court have been quite willing to expand the theories of discrimination under which protected individuals can bring their claims. We discussed the sexual harassment, development of sexual harassment jurisprudence in the courts as well, but that's, I think, quite different qualitatively from expanding a protected category of people.
Yeah, just briefly on this point, I think the Supreme Court majority got the Fair Housing Act case wrong because I think while certainly the purpose of the Fair Housing Act was to eliminate racial discrimination, it doesn't follow that it said anything that might serve that purpose in some way is required by the Act. Moreover, at the time the Act was enacted, as with Title VII at the time it was enacted, discrimination was understood as actually intentionally differentiating between blacks and whites or between other racial and ethnic groups and the like, rather than merely doing something that had a disproportionate effect on one group. That also means that Griggs was wrong, but I would say the same thing about Griggs that I would say about these cases on sexual orientation, which is that although when Griggs was decided back in 1971, I think it was an incorrect interpretation of the statute, it has been a precedent for many years now, and under this doctrine of giving deference to statutory precedents, I think, unfortunately from my point of view, Griggs cannot be reversed except by an act of Congress at this point, and I would say the same thing about these decisions which say that Title VII doesn't apply to sexual orientation discrimination.
More questions? Yeah.
So I was wondering if you could comment, Professor Somin in particular, but really anyone on the panel who could comment on the agency's, basically the level of deference given to the agency's interpretations, and whether or not really sort of in counter hypotheticals, if we could, look at how that would differ from other agencies, and whether or not you would support a change in the agency's underlying authority as one way of dealing with the issues arising in this area.
Yeah, so I'm actually not entirely sure whether the EEOC is even entitled to Chevron deference. I'm sure there must be precedent in this area. I'm just not sure what the precedent actually says. In general, in recent years, the Supreme Court has been less and less willing to defer to agencies based on Chevron, particularly on big major issues. And I think expanding Title VII to cover LGBT discrimination would be a big major change. It's not the kind of thing that Congress would typically delegate to an agency. And indeed, in the recent King versus Burwell case, the Supreme Court has reaffirmed a doctrine that in general agencies will not get Chevron deference on big major policy questions, such as in that case, whether exchanges established by the federal government have the same legal rights as those established by the states under the ACA, and the same thing applies here. So I would be surprised if the Supreme Court would give Chevron deference to the EEOC in this area, even if the EEOC is generally entitled to it on other lesser issues.
Yeah, I would just say that the EEOC does not get Chevron deference, at least with respect to Title VII interpretations, again, because Congress did not confer the agency with substantive rulemaking authority. And there was an important case that was decided last year, the Perez versus Mortgage Bankers Association. Is that it? Mortgage Bankers Association? Yes, I think so. In which the court talked about the different types of rules that agencies can make. There's legislative rules that are subject to public notice and comment, public notice and comment rulemaking, and then there are interpretive rules that are not subject to rulemaking, notice and comment rulemaking. Rules that are subject to notice and comment rulemaking are entitled to a level of greater deference than are purely interpretive rules that are not subject to notice and comment rulemaking. The EEOC has never issued a Title VII rule. I shouldn't say never. There were a couple of rules in the 80s when Justice Clarence Thomas was the chair of the EEOC that were put out for public comment, but by and large, the agency does not put out its Title VII interpretations to notice and comment rulemaking because it doesn't have substantive rulemaking authority. So what the Supreme Court has said is that we will accord the EEOC's Title VII interpretations respect, but only to the extent that those interpretations are persuasive. are reasonable and persuasive.
Ray, do you know, does the same limitation for Title VII about the not substantive rulemaking, does that apply to the Americans with Disabilities Act also?
No, the agency has substantive rulemaking authority under the ADA as well as the ADEA. So those are two clear contrasts.
Yeah, and I will just say, and just from my experience in teaching some of these cases, is that courts really like to knock down the EEOC. Remember, the purpose of the EEOC is, its stated purpose is to eradicate discrimination, right? And so that's what it's trying to do, and I think that they are cutting edge, and I think in this particular case, and I don't always agree with the areas, the ways they're going, bless you, in terms of cutting edge, but in this particular case, I don't think you're going to see a lot of deference to the EEOC. Whether any individual thinks they're right or wrong about this interpretation, you're not going to see a lot of courts that are going to say, and with probably one of the reasons because they don't have the substantive rulemaking authority, but also courts are going to decide this themselves, and this is, I think we all agree, whether or not we agree on the merits of this interpretation, is that this really is a backdoor way to get it in, right? Is that ultimately that's not what this statute was intended for. Whether or not it's a legitimate interpretation of it is a different question, but it's not, there's no question that that's not what the original intent of the statute wasn't to cover this type of situation.
I'm going to do something slightly unorthodox in deference to our missing panelist, and I'm going to ask a question for both of you, two questions. The first one is, by that standard, should the Board of Immigration Appeals and other adjudicatory bodies not receive deference? And the other question is probably more for Professor Somin. Do you think that on-call was a wrongly decided case in extending sex discrimination to cover male-on-male discrimination, despite saying that the drafters did not see it that way, and the fact that some time had passed since the original passage where it was being interpreted?
I claim ignorance on the Board of Immigration Appeals. I don't know what their congressional authority is, so I don't know.
So I would have to look at the statute on the board, and in general, a lot depends on sort of what authority was given to a particular agency and the like. It's very fact-specific. On Kale, I think it's a very different issue from the ones involved in the LGBT case. And Kale simply says, given that we've already held a long time ago, rightly or wrongly, that sexual harassment is covered by the statute, the only question that was covered by Kale that was new was, what if it's men sexually harassing other men as opposed to the more common case of men sexually harassing women? And it has long been true under Title VII, other anti-discrimination laws, that the identity of the person doing the discriminating, legally speaking, doesn't matter. Blacks can discriminate against other blacks, and that still can violate Title VII, and other discrimination law, men can discriminate against men, women can discriminate against women, and if that's true, generally speaking, then there's no reason why sexual harassment discrimination should be different. If it was women harassing a man because he was a man, that would clearly have been covered, so there's no reason to think that men harassing a man, if it was indeed based on his gender, which in this case it was, that should be covered. I would note, by the way, that you mentioned earlier, I think the case of the equal opportunity harasser, there actually is a Fourth Circuit case from the 1990s which covers this very issue called, I think it's called Lack versus Day, and the Fourth Circuit did indeed rule that the man who was an equal opportunity harasser, his nefarious activities were not covered by Title VII because although he was engaged in bad and reprehensible behavior, it was not on the basis of sex. And I think doctrinally that's actually correct.
And that's the key, right? The key is in the same-sex harassment cases, in all of what the good professor has said, the key is the because of. The harassment, the discrimination has to be because of race, color, religion, sex, or national origin, not because of sexual orientation, but because of sex or race or religion.
And I had not heard of that particular case. That's interesting. I'll look it up. But if you had asked me what circuit it was and what time period it was, I would have said Fourth Circuit in the 90s. That sounds about right.
So you can cast aspersions on the circuit, but the reasoning, I think, is correct. There's a lot of bad behavior in which we can harass other people in various ways, but this Title VII, even as interpreted by the Supreme Court, doesn't ban all nefarious harassment of any kind, only bans it when it's on the basis of sex or race or other protected classifications.
No aspersions. We're in the Fourth Circuit. It's all good.
Yeah. Okay.
Professor Somin, I know you have to leave slightly early. Did you have any closing words that you wanted to
So I still have another 5 or 6 minutes, so I'm willing to stay
so do
for
we have
that
any other
time
questions?
until people ask questions.
Hello, thank you for coming. I'm Andrew Howard, a student here at Mason. So going through all the case law, like Price Waterhouse and On-Call, the court has always been very meticulous in which, in the progeny, like you can't claim sexual orientation discrimination under Title VII. It's flat out said that. However, it's also indicated, but if you plead similar to Price Waterhouse that it is based on gender conformity, that's okay. My question is, with the EEOC's recent opinions, we're pretty much just being honest and eliminating artful pleading in terms of that. Is that something we shouldn't give credence to, or is it something that we're just being honest about?
I think it's
instead
an
of
end
hiding
run.
it under Price Waterhouse, we're just being upfront about it.
I think it's an end run around the statutory problem. So you just come up against this hard wall that is the language of the statute. And I think the court correctly in Price Waterhouse said that, hey, look, you can't mask sex discrimination in terms of in terms of femininity or masculinity. That is a form, essentially, of sex discrimination. All you're doing is calling sex discrimination by a different name, if you will. You're trying to get around the prohibition against sex discrimination by saying that, well, it's not her sex, it's just the way she looks. She makes people uncomfortable because she doesn't wear makeup and she wears her hair short or whatever. That's really a pretext for straight up sex discrimination. I think the case is much different here with respect to what the agency is trying to do. Yes, you can have the same type of thing happen with respect to gender nonconformists and conformants and LGBT individuals, but it's not the status that's in play. Do you know what I mean?
Yeah, so I think there is a sort of a genuine gray area here because the Supreme Court has said that for many years now that sex discrimination and its coverage under Title VII extends to discrimination based on gender nonconformity. So if a man doesn't behave as a real man or as you think a real man should behave and you fire him for that reason, then that is covered. And obviously, one of the main reasons historically why people were hostile to gays and lesbians is the perception that they weren't conforming to what people thought was appropriate behavior for their genders. I think there are some gray areas. Nonetheless, I don't think you can use this doctrine to shoehorn in a general ban on sexual orientation discrimination because there are these decades of precedent which say that sexual orientation discrimination is not covered. So what you will end up with, I think, is some difficult sort of boundary line cases where you try to draw a distinction between gender nonconformity discrimination and sexual orientation discrimination, and I readily admit that's going to be a difficult distinction to make in some cases.
And remember that you don't have to be gay or lesbian in order to have a gender nonconformity
Yes, that's true. That's true.
claim. You can be a masculine woman who's heterosexual. You still want to be able to make out that claim because you're being discriminated against based on your gender nonconformance or nonconformity.
Yeah, I mean, I think your question is a really good one because it's something that's always struck me as well. I mean, the bottom line is that the gender nonconformity theory is that if you're gay, then that doesn't conform to our normal, view of what a man should be interested in, right? I think that Commissioner Burrows said, I think a traditional view is that a man should be attracted to women. And so if you're gay, by definition, you're nonconformist, right? So I think it is artful pleading. And I think that the question of whether or not it should be covered or not is an entirely separate question. But I think we're all in agreement sort of the backdoor way to do it with PricewaterhouseCoopers ultimately comes to a lot of artful pleading. And the difference between pleading something as, a PwC violation versus just, gay or LGBT discrimination is very gray area, and it comes to good lawyering. And so your question of whether or not this was just an honest way to do it, I think that's fair. The problem is the EEOC, as we've been talking about, doesn't really have the authority to do that. So while they can do it in the federal sector cases, and they've done that, they don't have the authority to do it in the private sector cases.
Professor Somin, you mentioned about the difference between public and private sector. Two questions. It's a two-part question. So the first one is, don't you think it has potential to create a very segregated society? And you mentioned the freedom of association, but other than that, are there any benefits to have that distinction between public and private sector?
So it's two reasonable questions, and sadly, after I answer, I do have to leave. Not because I'm afraid of the public reaction I'm going to say, but it's because I have to go teach a class. You can imagine situations where it would create a very segregated society. I think that's highly unlikely with respect to gay and lesbian discrimination today, given that the vast majority of the public, and certainly the vast majority of business owners, by an even greater extent, actually oppose discrimination against gays and lesbians. What you're really going to see is a small number of dissenting employers, dissenting either for religious reasons or bigoted reasons or some of both, who would refuse to hire gays and lesbians, but the vast majority, I think, would not. And therefore, you wouldn't see this kind of segregation, so I think it would be very unlikely to emerge. On the second question, what's the benefit of freedom of association? I think part of the benefit is that I think part of it is the argument for it is not a consequentialist. On one, it's a argument based on individual freedom. The freedom of association is an important part of freedom that you have, whether or not it benefits you in a utilitarian sense. But I think there's also utilitarian benefit as well for two reasons. One is that people are in fact made unhappy and uncomfortable when they're forced to associate in ways that they don't want to do on both the employer and the employee side. And also there are costs to generating litigation that in many cases litigation is expensive and difficult, even if often incorrect or unfair charges can be made. So there are social costs to bringing more issues into the courts as well. And sadly, on that note, unless you want to follow up very quickly, I do have to go and teach the class.
Well, thank you for can't talk. Thank you. And maybe this would be well, does anyone have any more questions for Ray Van? Well, maybe this would be a good time for if you have any closing remarks, and I'll sort of raise one more question. We heard Commissioner Burrows talk about necessarily being gender stereotyping, as opposed to adding new words to the statute. How would you respond to that, and to the idea that sexual orientation and gender identity discrimination is necessarily gender stereotyping?
Sex discrimination, actually. I think the language of the ruling says that discrimination on the basis of gender identity is necessarily discrimination on the basis of sex. I don't see that. It isn't so just simply because the EEOC has said it is. There has to be some basis in the text and the longstanding court interpretations of Title VII, and there just isn't that authority. Maybe we'll get there at some point, and you don't have to go back to the 80s and the 90s to deal with these cases. There was an appeals court case decided in 2007, the Estidi versus Utah Transit Authority case, in which the court said that Title VII does not prohibit discrimination on the basis of sexual orientation. As recently as 2007, yes, that's almost 10 years ago, but it is clearly much more recent than the cases of the 1980s and 1990s. In terms of closing remarks, again, I'd just like to thank you all very much for not leaving the room when I started talking and for inviting me to participate in this lively and fun discourse. I wish that Commissioner Burrows could have joined us, because I'm sure she would have had some interesting counterpoints to my points, or points to my counterpoints. But I'm always interested in hearing from folks, so if you have questions after we conclude, feel free to shoot me an email or give me a call. I'm happy to talk about them.
Yeah, thank you, Ms. Van, and thank you too to Mr. Rosenblum for being here today and moderating. It's very much appreciated.